Mr. Harris.
Good morning, Your Honor. Can you hear me okay?
I can. Ms. Stein, how are you? Okay.
Good morning.
Good morning.
Afternoon.
Mr. Harris, do you want to reserve some rebuttal time?
Yes. Good morning, Your Honors. Officially, my name is Andrew Harris on behalf of the plaintiff, and I would request 5 minutes for rebuttal.
Very well. We're ready when you are.
Thank you, Your Honors. May it please the court. We are here on following a defense verdict in a medical malpractice trial, of course. We've raised 3 separate issues individually for a new trial and also cumulative error. I'm going to, if I can, go straight to the closing argument with Mr. Dukes. The defense has characterized it as an isolated statement that Mr. Dukes made when it was hardly isolated at all. If we could just go through, he was characterizing Dr. Mitchell, who was the sole expert witness in this case for the plaintiff, the key witness on standard of care and causation, Dr. Mitchell. And in the course of closing argument, 5 different times, Mr. Dukes told the jury in addressing Dr. Mitchell's testimony that in rebuttal, Mr. Ricci, plaintiff's trial counsel, that maybe there would be an answer that Mr. Ricci could come up with to try and explain away what Mr. Dukes characterizes Dr. Mitchell's testimony. The 5 areas, one had to do with the timing of when Dr. Mitchell read depositions. One had to do with whether an alleged infection was the cause of death. Another issue had to do with how much money Dr. Mitchell had been paid, where the defense Mr. Dukes mischaracterized the record evidence, but suggested that Dr. Mitchell was not telling the truth. And so for each of these windups by Mr. Dukes, he told the jury, maybe there's an answer or a reason. What happened then is that Mr. Dukes at page 1419 and 1420, he told the jury what the reason was. And what he told the jury was, he talked about how Dr. Mitchell was the biggest customer for the plaintiff's trial counsel's law firm, Cersei Denny. And then he told the jury, here was the mystery for the jury, in quote, maybe these things Dr. Mitchell said are explainable because he sold a little piece of his soul for his biggest customer and $26,000. I've been practicing law. I'm sorry, yes, Your Honor.
Let me stop you right there, because I agree that, you know, that is it's certain whether or not something like that should ever be said. You would agree that this case was a battle of the experts, right?
Yes, Your Honor.
And
correct.
that both sides were going after each other's experts in closing argument, right? You had referred to Dr. Systrom as a career courtroom doctor, said it was a good source of income, and he testifies in court so often he asked the judge for permission to approach. I think as to, I'm not sure if it was for Bell or for Systrom. Now he got paid $35,000 just to tell you that one word in the chart is what was going on with Mr. Keener. And you were both going after each other's experts. And what was said about your expert, but apart from the statement that he sold a little piece of his soul, which is inflammatory, no question. Everything else was a correct statement based on the record evidence, wasn't it?
No, that's the thing, Your Honor. The sentence cannot be put in isolation because of the windup by Mr. Dukes. The 5 different areas which were not correct characterizations of the record evidence, but it was the reference, ladies and gentlemen, Mr. Ricci in rebuttal. Maybe there's an answer that Mr. Ricci can provide you as to all these conflicts in the evidence. How is Mr. Ricci supposed to rebut the statement that he is in this partnership with Dr. Mitchell of selling their souls? And defense counsel says, well, the phrase "the devil" wasn't used. Selling your soul to the biggest customer. I've done appeals for 15 years. I clerked at a court. I know you all have seen thousands. I've never seen a windup like this in a civil case lead to this. Except perhaps the recent case I just provided this court. I haven't personally seen it, but the Nolasco case that I provided a supplemental authority last week. The 3rd District last month held it was fundamental error, unpreserved objection alone, because plaintiff's counsel in that case referred to defense counsel as a hired gun. and a liar.
Walk me through, Mr. Harris, because I've got to be honest. Like, when you read these cases and you read the comments that are given to jurors after a week-long trial in this case, and after a battle of the experts, where there were competing opinions thrown around, and all these experts are getting paid various amounts of money. What is it about what you are terming an inflammatory statement? For purposes of this question, I'll accept that characterization. What is it about an inflammatory statement that makes it such that a week's worth of trial and judicial resources and jury's time should be thrown out the window and started all over again? Help me understand that. Like, what pristine sense are we protecting these jurors from, such that they can't discharge their oath-bound duties because of this kind of a statement?
Right, and again, with respectfully, it wasn't just the one sentence, but the sentence itself.
I get it. It's
right.
The rope-a-dope. He keeps saying it, and then here's the punchline. I get it.
When you sell a piece of your soul to your biggest customer, who happens to be plaintiff's trial counsel, there is no means that plaintiff's counsel can rebut that to the jury. You have sold your soul out. You have given up all credibility, your entire integrity, the plaintiff's counsel and Dr. Mitchell.
It's closing argument. The jury doesn't have to believe that. I mean, you're almost veering into the jury might literally accept that he did this, and I don't think that was what was trying to be conveyed. And I seriously doubt that there was any danger that this jury was going to veer into that. So help me out. Assuming that it is a grossly improper rhetorical flourish, why does that damage what might otherwise be a perfectly fine trial and verdict?
Your Honor, if we could rewind in time before the special decision from the Florida Supreme Court, I think it would be fair for you to put the burden on me as the appellant to explain why our client was harmed. But of course, after special, which defense counsel does not directly cite in her answer brief, the burden is not on me to prove harm. The burden is on Ms. Stein's client, Mr. Dukes, to prove that there was no reasonable possibility whatsoever that this could have affected the verdict. This was a closely contested case. The heart of the case is what the expert witnesses, Dr. Mitchell, that was the plaintiff's entire case. And so the burden is on the defendant. And I would just admit the third district last month held it was fundamental error. And there was a reason for that. The third district, their opinion, as I said at the end, we demean ourselves in the system of justice we serve when we permit this to occur. This is not personal about Mr. Dukes. This is not personal about Dr. Thomas, but we're not entitled to a perfect trial. We were entitled to a fair trial, and we were deprived of that. This is not a game. Mr. Ricci talked about a quarterback of the team in his rebuttal, and that was referring to the facts and the evidence. But this is not a game. This is our client's one opportunity for a fair trial, and we did not get that. When you demean the integrity. So
if I understand your argument is, number one, I don't have to show that this damaged me in any way because it was improper. And number two, I think what I hear you saying is that because there is some kind of there's a moray that we do not demean the process, right? And this demeaned the process. We can no longer trust that the verdict was fairly obtained. Well, is that how you're reading the third DCA's decision?
Well, certainly the third district took a stand in finding that to be fundamental error alone. There were three different aspects of three independent grounds for fundamental error, and one was the reference when we talk about the process. But if I may, we would meet the test for a new trial under pre-special as well. When you have a closely contested, this was not a 4-week-old trial. Angle cases are sort of sui generis, right? And
I wouldn't argue with that.
In a 3-month Angle trial, and what lawyers, can get away with there. But if we remove ourselves from an Angle case, I'm not aware of a single case under Florida law which has ever approved with this long windup, and then to demean the integrity and credibility of the critical witness in the case.
So, Mr. Harris, and this is just kind of like what I'm pulling away from your argument, and correct me if I shouldn't be pulling this away from your argument. Please get me back on the right course of what your argument is, or if I am on the right course, and this is the point. let me know, because I mean, I want a candid view of this. Is it your position that there are just some things that are so beyond the pale and so inherently demeaning to the oeuvre of the imprimatur of judicial proceedings that they just cannot be said, such that in order to ensure that we preserve that integrity, regardless of whether it might or might not affect the verdict, if it's just so beyond the pale, we are not going to reward the other side with getting away with it. We're going to make them do a new trial all over. Is that kind of what you're driving at?
Not quite. This is not personal about Mr. Dukes. This is not personal about Dr. There is an element of the process here which is important, and the third district made that clear. But the specific focus is that this is our one opportunity, and we have one shot. We're entitled to a fair trial. And when you compare the key witness in the case selling his soul for money, it's fine. Like, referring, and I know, the two wrongs don't make a right, which defense counsel focuses on. It says, well, look what plaintiff's counsel did. Well, as plaintiff's counsel, Mr. Dukes told the court, look, I just used a variation of the phrase courtroom doctor. With all due respect to Mr. Dukes, this is not a variation of referring to Dr. Mitchell as a courtroom doctor, as somebody. It is fair game to question and say, you were paid $30,000, so you're more likely to get favorable testimony here. That would be fair game in a trial under current Supreme Court precedent. But you cannot, there is no means when you say that someone is akin to selling their soul to the devil. And so, yes, there's a process part to it. And I have no doubt that if we were in the third district under last month's opinion, where we preserved the issue here, and I understand you're not bound by that decision, but we don't have to get to a fundamental error analysis here. We're directly under special. We're directly under a closely contested case fought by both sides. And when you have this long, not isolated statement in closing argument, how was Mr. Ricci in rebuttal? Defense counsel kept on telling the jury, look, Mr. Ricci can come up with an answer here, 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 and here, or he needs to come up with an answer. How does he respond to this in rebuttal? He can't. He can't go back to the evidence. He can't focus on the discrepancies because he's been characterized, plaintiff's counsel has been characterized as being in a conspiracy, essentially, with their own expert witness, the only relevant, the key witness in the case, to sell their soul to the devil. And you cannot, I don't think that this court should tolerate that as a principled matter, but this is not, we're not interested, I'm not interested in Mr. Dukes. We filed the motion for sanctions down below. I didn't ask for that on appeal. I didn't renew that. I'm not asking for a referral to the Florida bar. What we just want is a fair trial. And we were denied that by, Mr. Dukes crossed the line and then some at trial. And we are entitled, and especially under special, the burden does fall on the defense to prove that there's no reasonable possibility that it's impossible for them to meet that test here. The Supreme Court has made that test impossible for good reason, to disincentivize parties. You mentioned, why should we redo? That's precisely why. Because if a party, this is plaintiff or defense counsel, can get away with this comment after the parties have a 5-day trial and spend tens of thousands of dollars to have their one opportunity for a jury to fairly hear the evidence, and it gets taken away because of what is the most outrageous closing argument I've seen in a transcript in my 15 years in a civil case. And I know this court sees, outside of Engle cases. And there's no way for them to rebut the harmless error test under special in my mind. And so the process is important, and the third district emphasized that at the end of their opinion, but I want to focus on our entitlement to a fair trial, which we were deprived of here. If there's nothing else on the closing argument issue, I'd like to go and focus on the other issues from trial. I don't know if you have any follow-up on that issue. Okay. The other relevant thing here is that we are not just seeking a new trial because
Mr. Harris, let me give you a heads up. You get about 1 minute before you get into your rebuttal time.
Okay, I appreciate that. If I can just briefly, the other issue which in of itself would warrant a new trial was that the defense was allowed to present 2 causation opinions in this case. Dr. Bell, there was a long discussion before his testimony where defense counsel was told to discuss with Dr. Bell before he testified that he would not give any causation opinions. He was instructed of that, the trial court instructed, and at the very beginning of Dr. Bell's testimony, he stated it was impossible. It was impossible for the plaintiff to have bled to death. That is directly a causation opinion. It does not get any more clear. The trial court acknowledged that it had crossed the line. But the trial court and defense counsel says it was not preserved. That issue was not preserved because we did not specifically make a motion for mistrial. But the trial court itself said it was denying the motion for mistrial, and plaintiff's trial counsel confirmed with the court, so you're denying the motion for a mistrial. So it was preserved. And that, again, in a battle of the experts, for the defense to have two experts able to opine on causation of death, deprive us individually, and then of course under cumulative error. And if I can just briefly, before my time yields, the other issues, there was an improper bolstering of Dr. Systrom, who was the only scheduled causation witness. Defense counsel in direct brought out without solicitation, without any mention by plaintiff in opening, had Dr. Systrom confirm that he was against Mr. Dukes in another pending case. That is anticipatory. That was non-anticipatory rehabilitation, which is not permitted under the case law. That is clear. And there was also a golden rule violation as well, which we addressed in the briefs, which cumulatively. But of course, the main two issues, closing argument and the double causation opinion. I will yield my time for rebuttal. Thank you very much.
Thank you, Mr. Harris. You get about 4 minutes for your rebuttal, all right?
Thank you.
Hold on, let me get my clock going. Okay, Ms. Stein.
Thank you. May it please the court, Dinah Stein on behalf of Dr. Thomas and Bond and Steele. And starting with the closing argument point, I'm going to say first and foremost, we disagree that special applies, and plaintiff has not explained why it would have applied to this particular point. I know they cited it in their multi-point brief, but special applies to errors made by the trial court in introducing or allowing evidence and not in motions for mistrial. It doesn't matter, I don't think, based on this record, which I'll get to, but I just want to put that on the record. But what we have on the record, and I think this is very important, is the gut visceral reaction of the trial judge, because the parties came to the bench and he gave his impressions and he said, I've never heard this comment, just as Mr. Harris said, he agreed, I've never heard it in any context. And he said, there are some things you can say, some you can't. He said, it could have been worded differently. He didn't say it was improper, but he came down by saying that it didn't cross the line. He was there. He commented how plaintiff's counsel had pretty much torched the defense expert in his closing, essentially saying it's not a quid pro quo. Two wrongs don't make a right. We're not saying that either, but you set the tone. This is a battle of the experts. You called their expert a courtroom doctor, as was stated, and so Mr. Dukes is allowed to respond to that. The court also offered, even though it's unclear what his ruling was, it seems like he found it was not an improper comment. We're not sure, but he offered the plaintiff a curative instruction, which the plaintiff rejected. So that's first and foremost. Now, as far as the propriety of the argument itself, if you look at this record, this wasn't an isolated statement by Mr. Dukes in opening, or just simply saying, I know that these experts are liars. He methodically went through Dr. Mitchell's testimony in closing. There was no objection because it was all based on the record. He didn't misstate anything. And he talked about how Dr. Mitchell, at the time of his deposition, was his only customer was plaintiff's law firm. He had 10 or 15 cases with them. He greatly understated the money he was paid when he testified to the jury by half. The defense pointed that out to the jury and cross. This was an expert who refused to even concede that Mr. Keener, the decedent, wasn't healthy when plaintiff's counsel in opening and closing conceded that he was not a pillar of health. And in fact, he was
Stein, I don't know that there's really that much of a controversy about whether or not the subject of impeachment of an expert through inconsistent testimony, through the fact that they're being paid, et cetera. I don't think there's any controversy about whether or not that's fair game, and even whether or not there was a record basis for them to engage in some questioning of the expert's credibility and cross-examination. I think it just comes down to what Mr. Harris, I think he repeated it about a dozen times, is that there's this line that got said that, you know, he sold a little piece of his soul. That is certainly inflammatory. And to me, what is challenging about that is there is some case law that seems to indicate, there are certain taboo terms out there that thou shalt not refer to in closing statements when you are trying to challenge someone's credibility, hired gun being one of them. How do you square the law that says you can't call him a hired gun, but you can say that he sold a piece of his soul?
So the piece of his soul was a term of art. He was not using any reference to biblical terms. This is a common parlance.
I'm not sure it's common parlance or a term of art to suggest, to the extent that you are a believer in this, to suggest that someone sold their immortal spirit in exchange for lucre. I don't know how that gets turned into a term of art when it is used like an arrow to go after this gentleman's credibility and character.
So first of all, again, he prefaced it with a very extensive discussion of credibility and character. So that's
Sure.
Number one. And also, again, plaintiff's counsel had originally set the tone by saying that that the defense bought a sepsis defense for $35,000. I think the best way to show this is to compare it to cases where it does cross the line into reversible error. And the example that counsel uses is the recent case from the 3rd District. And, that's a case, one of the few cases I think I've seen that actually fell into the Murphy fundamental error standard, which says, when you start.
I thought it was dead in civil law, but well, apparently it has a breath of life.
But what's interesting about that decision, Murphy did say that exceptions may be when you bring out, I think in that case, it was racial inequities, or I forgot how phrased in Murphy. And this, in fact, was done in the Florida Peninsular case where the comments were sexist. And the trial court, and another very key difference here, the trial court was offended by the comments. He commented, or he said that they were offensive, sexist, and inappropriate. So the court, calling a female attorney a drama queen, in that case, they not only went after the witnesses, but after counsel, and called counsel liars, which, that's not based on any evidence. So, this is one of the very few, I agree, Your Honor, there've been practically no cases under Murphy that allowed fundamental error, closing argument. But I think this falls into that, where you now attack counsel or somebody based on, sexism or racism or, something like that.
I'll turn us back to kind of the question I posed to Mr. Harris, and sorry for harping on this for so long with both of you, but it does seem like there's at least an element lurking here of courts not wanting to reward inflammatory, over the line closing arguments, and kind of sending a message, for lack of a better term, to trial counsel. Hey, there is a line, and you cross it at your own risk, and we're not going to reward that kind of behavior. Whether that's proper or not, I suppose that's debatable. But to the extent that is a driving consideration, how should that fall in this case? Because I think a good argument can be made that it's one thing to question an expert's credibility and to make kind of offhand references. He's bought and paid for. These guys, one big client. It's distinct, categorically different to say this guy sold his soul. And after doing kind of the long lead in that leads up to that as a featured punchline. So help me out with that.
Okay, well, certainly. And first of all, appellate opinion should be finding error. If there was reversible error or prejudicial error, It's not a vehicle for punishing lawyers or sending messages, or it shouldn't be, and it can be done in terms of just a written opinion with an affirmance. But I'd say in the context of this case, it's a draw. I mean, if we're going to use examples, this could have been just equally turned on the other side for calling Dr. Systrom a courtroom doctor, et cetera. The other thing I'll say is that there still is a very large amount of discretion and deference in situations like this to the trial court. And I would submit that this court shouldn't overlook that fact that we do have a record of the trial court's reaction. And this is an experienced judge who said, it was different terminology, but I don't think it crossed the line. One other thing I'll just say for perspective, but under Murphy and the Craig versus State and the other cases, I think under this record, Mr. Dukes could have stood up and said, Dr. Mitchell is a liar. I mean, I think that would have been fair comment on the evidence. He made the credibility argument, and he probably could have said, he's a liar, he lied. I mean, that I think is stronger than, he sold a little piece of his soul, which was immediately stopped by an objection with no curative wanted, even though it was offered. And the court asked Mr. Dukes to just move on. So in terms of this record, I just don't think this is the case for it. The other thing I'll say is, and I know this is not binding on this court, but the 11th Circuit addressed, just coincidentally, an almost identical argument, the U.S. 11th Circuit in the case we cited, and found it not to be improper. Now,
question, Ms. Stein, that 11th Circuit case, when was that issued?
That was, I believe it was 1988. It was an older.
Before this closing argument?
Yes. I mean, that was on the books. And that I think the 11th Circuit actually found it proper or appropriate under those facts. So if there's ever a situation where, I just don't think appellate opinions should be a tool for punishing counsel, and particularly not on this record. This record just doesn't invoke that. It was a very hard-fought closing argument. It was a hard-fought trial. Both attorneys really went after the experts for the other side. At the very most, it's a draw, but it certainly didn't impact the case. And plaintiff, they don't even try to show how it impacted the case. I mean, this is a week-long trial with excellent attorneys and a lot of evidence, and that's what the jury was looking at. I do want to just briefly address the other points. And so I don't want to get off this point unless there are other points to be made. But as far as Dr. Bell, plaintiff still hasn't identified the legal objection to Dr. Bell's statement. I mean, this comes down to a 9403, I believe, of whether he was allowed to say that there was no way a patient bled to death. But there's been no pretrial order identified or limitations on witnesses. The plaintiff's counsel didn't move to strike the causation expert before he testified. So I'd submit that's a non-point.
Actually, Ms. Stein, I think if I remember the way it played out in the transcript, there was an objection contemporaneous with when he said there's no way the guy bled to death. And at least I recall there was a mention of maybe we should strike Citrum if this guy's going to end up being talking about causation. And I thought this all pertained to a kind of the garden variety trial rule, one expert, one issue, so that you're not stacking up cumulative experts. I thought, but correct me if I'm wrong.
Right. No, it actually wasn't. There was no pretrial order limiting witnesses. Now, counsel did say that, and the judge limited the testimony based on defense counsel's comments in the deposition that he would not give causation testimony. It wasn't based on any pretrial order, but he said, this is kind of, I'm learning this, so let's just revisit this if we need to. So plaintiff had the opportunity after Dr. Bell made his single comment, which is almost identical to the rest of his testimony about standard of care. And all they did was renew the motion for mistrial, when Dr. Systrom testified, never moved to preclude him. So again, that's what I'm saying is this is not one of those garden variety cases where we have just a pretrial order that says one per specialty. There was no pretrial order. And plaintiff's only point on appeal is that there's no right to unfettered cumulative testimony. We agree. There wasn't any unfettered cumulative testimony. We're talking about one sentence. And again, that sentence was almost identical to most of Dr. Systrom's causation testimony, which plaintiff didn't object to. So I would submit that is a non-issue. And finally, as to just the other points, which plaintiffs just kind of they don't assign error to the final 2 points, but so much, and they concede that on their own they wouldn't raise grounds for a new trial, but throw it into the cumulative error pot. On that, I'd submit 0 + 0 = 0. I mean, if neither of these are error that are reversible, they shouldn't go into the hopper on this whatsoever. But in any event, Dr. Systrom, the whole anticipatory rehabilitation, I think what's key is that plaintiff never said when they objected that they weren't going to ask about that. I mean, that's makes this right in there with the LeBron case we cited. The court said this is proper. And in fact, plaintiffs, the cross-examination started soon after talking about Dr. Systrom's fees. So that was purely proper anticipatory rehabilitation. And so, plaintiff and golden rule, of course, that it was just not a golden rule comment. You're allowed to ask an expert to just talk about what a reasonable doctor would have done or a reasonable defendant would have done. Courts have allowed, and a question wasn't even an argument to the jury. It was a question to an expert. Courts have never found that to be reversible, and in fact have specifically found it to be proper. So, the fact that the plaintiff has identified other errors doesn't add to the first point. The first point is the closing argument is absolutely not reversible error. The record shows that none of those other points add to it. Plaintiff cannot show that an entire trial needs to be vitiated because of one comment that the trial court didn't find crossed the line and plaintiff's counsel didn't want a curative instruction. So I would submit that the verdict and the judgment be affirmed. There's no error on this record and certainly no reversible error. Thank you.
Thank you, Ms. Stein. Mr. Harris, 4 minutes.
Thank you, Your Honors. If I can, regarding the issue of a curative instruction, what curative instruction could we have asked and received when defense counsel, after that long windup, told the jury that Dr. Mitchell had sold a little piece of his soul to plaintiff's trial counsel sitting in the courtroom for 20? There is no way you can get a curative instruction on that. There's no requirement under any case law to ask for a curative instruction. We move for a mistrial. If I can just briefly, the 11th Circuit case, which obviously it's a over 30-year-old case, it doesn't have the harmless error test that we have in Florida. But in that case, even the testimony there, or the closing argument about somebody selling a solo witness, there was no connection to the lawyers in the case. Here we had a direct connection. Dr. Mitchell didn't just sell his soul. He did so in conjunction with plaintiff's trial counsel.
So let me get this straight. So long as it's the right market for souls, it may or may not be an appropriate comment.
No, I'm not suggesting that there should ever be any reference to any witness selling their souls, but I'm just saying that it was one even more so here with the direct connection to plaintiff's trial counsel. There was no way for and again with the windup, where there were 5 aspects of Dr. Mitchell's testimony, which Mr. Dukes said, Mr. Ricci here, maybe he's got an answer for all this in rebuttal. There's no way to rebut a conspiracy of Mr. Ricci and Mr. Schwenke and Dr. Mitchell because of money, selling their soul, i.e. giving up all integrity, all morality to say anything. I would also disagree with Ms. Stein saying that it would have been permissible to call Dr. Mitchell a liar. That would not have been, but we're not here on that issue. Just like we're not here on whether the defendant would have been entitled to a new trial if they had objected to plaintiff's closing argument, which courtroom doctor, again, Mr. Duke twice after this issue told the judge there was nothing wrong with what I said. There was nothing wrong with that comment. Ms. Stein, who I have all the respect for in the world, seriously, she still cannot hear even, she called it a term of art, common parlance. That is just grossly, and that just to me does not compart with what should be acceptable in any case. And again, the focus is not on deterrence. That's an important part of it from the 3rd District and other courts. Hired gun, you're not allowed to use that, and they did cross the line. But ultimately, I want to just focus in on my client and the fact that we are not entitled to a perfect trial, but we are entitled to a fair trial. And that was clearly lost there. On the causation opinion, there was no pretrial order. There was an actual stipulation by defense counsel, which traced back to the deposition of Dr. Bell, where defense counsel represented Dr. Bell would not be offering any causation opinions. And then that came, this is not a 9403 issue. Defense counsel, before Dr. Bell testified in court there, I think at T798 to T800, represented to the court that Dr. Bell would not be offering a causation opinion. An opinion from a witness, which then came out minutes later that it was impossible that Mr. Keener bled to death, is quintessentially a causation opinion. The testimony which Ms. Stein says later on was essentially the same, was not the same. Actually, Mr. Schwenke told the court after his mistrial was denied, if you're going to allow, he didn't say if you're going to allow the testimony, but once the trial court had overruled, or once the trial court had denied the motion for mistrial, at the very least, defense counsel focus in on whether you see any signs of active bleeding going on. And the rest of the testimony at least focused in on the issue of whether there were any signs of active bleeding. But the statement, the opinion that Mr. Keener, it would have been impossible for him to bleed to death, that is a causation opinion that violated the actual concession made by defense counsel before Dr. Bell went up on the stand. And so that alone would warrant a new trial, and certainly in conjunction with the closing argument issue. Just one other thing, I'm not sure my time, Your Honors, but
One more comment.
What's that? I'm sorry?
One more comment.
One more comment. Defense counsel said special does not apply. It absolutely applies. The trial court functionally overruled the closing argument objection, and in any event, the trial court directly overruled or directly denied the motion for mistrial. The burden, we would meet the burden under a pre-special test, a closely contested case, a case where the key witness here was Dr. Mitchell, and of course the credibility of plaintiff's trial counsel, where they collectively sold their soul, but special fundamentally does apply, and they cannot establish, they're not even trying to meet the special test. And of course, then we go right to Nolasco from the 3rd District last week. I'm not asking this court to go to a fundamental error analysis and whether, the courthouse doors are closed for fundamental error. What is significant enough is that the 3rd District alone, we further find that plaintiff's counsel's argument.
You're going to have to wrap it up, Mr. Harris, please.
I was just going to quote, it was the reference that a hired gun warranted a new trial there. That's the exact same circumstance here, which went far, far more egregiously in telling the jury that Dr. Mitchell was selling a little piece of his soul in conjunction with the Cersei Denny law firm. So respectfully, we would ask for a new trial and to remand. So we received the fair trial that we were entitled to and were deprived of here. Thank you, Your Honors.
Okay. Thank you, Mr. Harris.